Hey, it's James, Follows Rights and Resources, hashtag how I got custody. If I had an attorney is telling me, well, we can't go 50-50, you'll never get that. You can't go for custody, you don't have a chance of that. We'll have to just roll with the system. Just follow the process. Just listen to whatever the guardian ad litem says. You know, a lot of attorneys will say, go meet with the guardian ad litem. Do you know what happens in a criminal court case? When the prosecutor or the person accusing the defendant, when they want to sit down and talk with them, you know what happens if they talk with them without their attorney present? The attorney gets outraged and they'll talk about ethical misconduct. That's when they'll get on the offensive. That's when attorneys really get on the offensive. You're going to talk to my client without me present? I get to govern and dictate what my client says to you so they don't incriminate themselves. Yet your attorney will tell you to go meet with the guardian ad litem or go to a mediator and spill some beans that can be used against you in court. And they're your lawyer supposed to be protecting and advocating for you. This is how insane family court is. But if I got an attorney that's doing none of those things that I listed earlier, I would be asking them, why did you become an attorney? Don't most people become an attorney to fight for justice, to fight against injustice, to help change things? You know, people who became attorneys around Jim Crow South times, they probably wanted to undo injustices against black people. Or, you know, like Gloria Allred, she's a feminist attorney. She's in there advocating for women and all the corruption in there. And she fights against stuff, even though the odds might be against it. You know, she was representing prostitutes that were suing Tiger Woods for manipulating them or something like that. And there were prostitutes, knowing that they were helping him have adultery and illegal sex for money. Attorneys do outlandish stuff all the time and falsely accuse people all the time. But your attorney won't go in there and fight for equality and justice in a court of equity, in a court where you're supposed to present oral arguments and persuasive arguments, and you have a prevailing party, and then which means you have a losing party, and you get to interrogate witnesses and impeach witnesses, which means attack their credibility and interrogate them. You have all these adversarial competition type of terms describing court, and your attorney's like, well, we don't want to get in there and look aggressive and advocate. What do attorneys usually advertise as? We are aggressive advocates for you. We will aggressively defend your rights. We will fight for you. They use the word fight in their advertisements all the time. Watch the next attorney commercial. We will fight for your rights. We will fight for you to get that compensation. We will advocate for you. We will zealously represent you. The rules of professional conduct, in case a lot of you who watch my YouTube videos, I mean, I got a topic on just about everything, and then people ask me stuff. You know, I've been watching YouTube videos for several months. If I was just starting out, I'd be watching every single YouTube video, or I'd be typing in a topic. When you go into my YouTube channel, there's a magnifying glass above the main video. If you're on a laptop, I don't think it shows it on the phone. There's a search engine within my website. I don't think there's you could do that on a cell phone. You have problems with an attorney. Why don't you type attorney in that search there? Or if you're on a cell phone, you can type in how I got custody, whatever topic, depositions, discovery, best interest of child, or whatever, attorney misconduct, CR11, whatever. You know, there's all these ethical codes that govern attorneys that they never follow, just like referees don't follow the traveling rule when LeBron James has the ball in his hand. But you can still hold them to that. You can still try. Who in the world makes $400 an hour and says, I don't want to try that hard because the odds are against it? Does a plumber say, oh, you got a backed up toilet, it's going to be a really tough job, I don't think I can take it because it's hard work? Or a cleaning job, or some pest control, or an accountant who needs to assemble your chaotic papers that are all over your dining room table. And this is a lot of work, and they make $50 an hour or whatever. It's a lot of work, and they still put it together, and that's their job. I had a guy, and I mentioned this in another video, I had a guy who just talked to me today, and I said, tell your attorney to look up case law on motions to vacate by default and see what the leading case law. And he said, my attorney says he doesn't do appellate work. That's insane. The attorney won't look up case law or common law and use Lexis or Westlaw, the search engine tools that all the attorneys have. They have one or the other usually. The attorney is an attorney at law. He's supposed to advocate on behalf of the law, on behalf of his client. He does legal research, and he's an attorney at law arguing the law. And most of the law outside of the statutes is contained in common law, case law, or higher court precedent. And he says, I'm not going to go look that up because I don't go to the Court of Appeals and do appeals. You don't have to do appeals to look at the hard work of another attorney who got some legal precedent and overturned something or said, this is bad, whatever. This is a bad approach. Or like, let's say in Florida, if it's anything like Washington case law says that the courts don't like default judgments. The courts will liberally vacate or set aside a default because we want to hear the case on the merits. We want to hear the argument, the evidence. We want to hear both sides. We don't want somebody to win by forfeit. You know, your baseball team, the bus breaks down on the way to the game, you have to forfeit. Or, you don't cut weight in a wrestling match or a boxing match. They have to forfeit or whatever. You didn't actually lose. You lost by forfeit because you were a no-show. Same thing with a default. You never showed up. You never argued. Shouldn't the court want to hear the truth and the facts and bend over backwards for the best interest of the child? The problem is you go in front of a judge or these lawyers say, well, you kind of dropped the ball on that, missed the boat. Let's just go through the process. Because that's what they conveniently want to do in the factory that they work in where they're churning out this stuff. They want to do it according to their process and their MO. Not what the law says, not what my baby's mom's attorney, that guy would go look up case law and argue stuff with an evil twist on it and abuse the system and falsify stuff and stretch out the law. He's even looked up case law, and when he looks it up, he might say, you know what, I found this, Your Honor. There's actually an additional doctrine that you have to follow. The guy is looking up, doing research all the time. Even though he's a total a-hole, he's still doing the legal stuff. And then he's stretching it out and and he gets off on the challenge of manipulating the law in an outrageous manner. And he got away with it several times. And your attorney won't even try and look up stuff to find out what the law and precedent is? The attorney's got to be insane. Ask them, did you become an attorney to just go with the flow and go with the system? Or did you become an attorney to fight for justice and truth and fight against corruption in the system? And if they don't have an answer, they're a sellout. Why are you hanging on to them? You're sabotaging your own case. You don't care enough about your kids to fight your attorney and learn how to fight the right way.